You're watching The Legal Breakdown. So, Glenn, we have some really, really consequential news here from the Trump-aligned judge down in Florida, the classified documents case. We've got what seems like good news on the surface, but talk about the decision that was just handed down by Judge Aileen Cannon.
Brian, nobody should be fooled by anything Judge Aileen Cannon does. This is the Trump-appointed judge. This is a judge who owes her position on the federal bench, life tenure as a federal judge. She owes it to the defendant over whose criminal case she's presiding. That right there is a conflict nightmare. But as you say, we just got a ruling from Judge Cannon, which on the surface sounds like good news because she denied Donald Trump's motion to throw the entire case out based on the Presidential Records Act. Now, you would think that sounds like a good development, right? First of all, the Presidential Records Act does not apply to any of the criminal charges in Donald Trump's case. He's indicted on, among other things, 32 counts of violating our nation's espionage laws. And the Presidential Records Act has nothing to do with those criminal counts. It would be no different than Donald Trump making a motion to have his case dismissed based on magical unicorn immunity, right? So this is not a surprise. This is not unexpected that she would say, oh, okay, I'm not going to dismiss the entire case based on the Presidential Records Act. But the devil's in the details. And there are not many details in this two-page order. First of all, Brian, I can't tell you how alarming it is. I was a federal prosecutor for 30 years. I read lots of court orders, particularly court orders resolving what are sort of substantial legal questions or issues. In this two-page order, she doesn't cite a single case. She doesn't engage in any analysis. She does nothing other than to say, well, here's the applicable rule of procedure, and I deny the motion. But then she goes on to say something that is extremely ominous for sort of those of us who have been following along the minutia, every single development in the Florida case in which Donald Trump is indicted for unlawfully retaining classified documents, obstructing justice by refusing to give them back, and violating our nation's espionage laws. She says on page 2, let me set it up. Remember a couple of days ago, Jack Smith filed a scorched earth filing in this case saying, wait a minute, Judge Cannon, you're proposing to give 2 jury instructions, and those jury instructions say the Presidential Records Act means that Donald Trump is essentially not guilty of the charges. And Jack Smith responded by saying that's not an accurate formulation of the law. And if you give those jury instructions, you will be orchestrating an acquittal. You'll be orchestrating a not guilty verdict, and you'll be doing it at a time after the trial has already started, after the jury has sworn in, after jeopardy attaches. You'll be doing it at a time when the prosecutors couldn't appeal you if you dismissed the case. So he fired back a really strongly worded pleading saying, Judge, you can't give those instructions because there's no basis in the law for giving those instructions. And Judge Cannon, in her new flimsy little 2-page order, alludes to that. Here's what she says. Separately, to the extent special counsel demands an anticipatory finalization of jury instructions prior to trial, because if she were to do that, Jack Smith could appeal her decision without jeopardy having attached. To the extent that you're asking me to do this prior to trial, prior to a charge conference, which is a conference when we talk about the jury instructions, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust, which is just a bizarre formulation. But Brian, what she's saying there, and I feel like we're down in the criminal practice weeds here, she's saying, oh no, I will wait until after the jury is sworn. I will wait until after evidence has been presented. I will wait until after Donald Trump has put on his defenses, and then I still may give that lawless jury instruction about how the Presidential Records Act means the jury must find Donald Trump not guilty. And guess what, Jack? You can't appeal it at that point. Game over. This is the most mind-blowing potential abuse of judicial discretion imaginable. And here's how Judge Cannon finishes her order. She says, as always, any party remains free to avail itself of whatever appellate options it sees fit to invoke as permitted by law. Brian, I wish I could explain to our viewers how bizarre, how inappropriate, how nefarious and ominous all of this is.
So, okay. So yes, she didn't summarily dismiss the case based on bogus charges that wouldn't even serve as a predicate to dismiss the case. But given that she retained her ability to still dismiss the case once the jury is sat, which would mean that it's not appealable anymore, is this finally enough for Jack Smith to have a justification to have her removed?
It's more than enough. You know, the disqualification bucket runneth over at this point, right? I mean, she has shown herself time and again as being, at a minimum, incompetent because, Brian, this is judicial incompetence, this two-page order. It's hard to escape the conclusion that she's in the bag for Donald Trump. You know, she seems to be orchestrating not just a dismissal of the case, but a dismissal with prejudice after the jury has been sworn. Listen, in 30 years, I don't think I've ever seen a dismissal with prejudice after the jury has been sworn. Why? Because the parties and the judges know that it's not supposed to happen. That's not the way a case is supposed to play out. Now, if happenstance, the evidence breaks a certain way that nobody was anticipating, it's not beyond the realm of possibilities that a case would be dismissed after the jury has been sworn, such that the defendant could never be brought to justice. But I'll tell you, I don't think I've ever seen it. And everything that Judge Cannon is doing screams that I'm trying to position things to make sure I can accomplish this and I can get rid of Donald Trump's case with him never being held accountable.
Glenn, at this point, Jack Smith has to know this, right? Like, if you and I are talking about this, there is a 0% chance that Jack Smith and his Department of Justice prosecutorial team are unaware of what's awaiting them, right?
Yeah, and Jack Smith, I think, has to be engaged in the calculation right now of, okay, are we so far beyond the quantum of evidence we need to comfortably file a motion to have her removed from the case? It's called a recusal motion. Do we have what we need not only to be able to, in good faith, file that motion, because you don't want to do that lightly, right? You don't want to be accused of judge shopping. You want to make sure you've got the goods to back up a motion to remove a judge. And once you think you have the goods to file the motion, do you also believe you have the goods to win the motion? But, this is the kind of issue that has to be litigated in the full light of day. All of the parties need to have their positions fully made known to the court, first the trial court, then the appellate court, assuming Judge Cannon doesn't remove herself from the case, because that's the only way that whatever the outcome is of this case, of this trial, the people can have confidence that, okay, we the people got a fair shake at justice. Donald Trump was given a fair trial, but we the people were given a fair trial as well. And if at the end of the day a jury finds Donald Trump not guilty, extraordinarily unlikely based on the evidence, but at least we feel like everything was on the up and up, like the judge that presided over the case, even though she owes her very job to the defendant, Donald Trump, she ruled in a way that was bulletproof. It was fair, it was independent, it was impartial, and it was in accordance with the law. But at this point, I believe Jack Smith has more than enough to file the motion. I think he's got a very good shot at winning the motion. But there's no shame and there's no embarrassment in filing a righteous motion only to lose it because you can't quite prove to the court's satisfaction that she is unwilling to sit or unable to sit fairly and impartially. The motion has to be filed and litigated.
Glenn, to that point, if you had to deliver a message to Jack Smith that perhaps I and a lot of other viewers might want to clip and post on social media and drive some attention to and hopefully impact some of the coverage of this, what might you say to Jack Smith?
You know, I would say, with all due respect, because I have confidence in Jack Smith's ability, I have confidence in the decisions he's made, the tactical decisions he has made ever since he was appointed as special counsel. He has gone hard, but he has been fair. He hasn't shied away from bringing difficult challenges, like trying to pierce the attorney-client relationship when Donald Trump was trying to use one of his attorneys in furtherance of the commission of the crime. Jack Smith took that battle on and he won it, and the attorney was compelled to testify about, and in a very real sense, against Donald Trump, his former client. But I would say, you know, the American people need to have confidence in the outcome of this case down in Florida, a case in which Donald Trump has so dramatically compromised our national security. And we have a right not to have a former president do that to us, do that to our nation's security, do that to our democracy. But the only way we can have faith in the outcome of the trial is if we have a fair, impartial, and independent judge. And the only way we will know whether we have a fair, impartial, independent judge is if the motion to remove her is litigated in the full light of day and is resolved by the 11th Circuit Court of Appeals. That is the only way we will be in a position to accept the results.
And Glenn, in fairness here, I want to play devil's advocate a little bit so that we give both sides of this, you know, a more holistic view of what we're dealing with. Is there any reason for Jack Smith not to seek to have her removed at this point? Like, what's the downside here? He's done all this work, so why just blindly walk into the mouth of a volcano?
So the downside is, listen, if somebody quibbles with whether Jack Smith and his team of prosecutors have enough evidence to file the motion, not to win it, but to bring it in the first instance, then he could be accused of bringing a frivolous motion in bad faith because he just doesn't like the rulings of this judge. That is a downside, but it's not a realistic downside because I don't buy in to that argument. I don't think there's enough evidence to support that assertion. The other downside, anytime you file a motion to remove a judge from a case, there's a concern that if you lose the motion, that judge is going to hold it against you, is going to rule accordingly, is going to basically be looking to get back at you, payback for trying to have her removed from the case in the first instance, and the judge will have animosity with respect to everything you do as the prosecutor on the case moving forward, to which I would respond, Brian, when has Judge Cannon not had animosity toward the prosecution? And when has she not shown favoritism to Donald Trump? She's been reversed by the appellate court once before for abusing her judicial discretion by doing something to the extreme benefit of Donald Trump that the law did not permit her to do. So that's why I don't think there is nearly enough downside to bringing this motion that would stop Jack Smith from bringing it at this point.
Right. I mean, that's exactly what I was going to say. It would carry more weight here if there wasn't already a super hostile judge that's doing everything she can in Donald Trump's favor, which, by the way, the 11th Circuit, which is no liberal bastion in terms of a court had already claimed that she had done when she interfered on Donald Trump's behalf one time. And so now she's doing the same thing again. I think Jack Smith has absolutely nothing to lose by moving forward and seeking to have her removed because at this point, she's going to do whatever she can. She's already shown us that she's going to do whatever she can to help Donald Trump. And so if we want any hope of a fair trial after this years-long effort that Jack Smith has put forward to prosecute him in a fair manner, then we need a judge who's actually willing to preside in a fair manner over this case. So with that said, of course, Glenn and I will continue to cover this as soon as we have any developments. For those watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.